Today, we are going to discuss some of what your team needs to know about the new Personal Information Protection Law of the People's Republic of China, effective as of November 1, 2021. We will address who is subject to the law, what can happen if you violate the law, and also some of what persons subject to the new law need to know from a data governance perspective. The first question that most businesses ask is whether they are subject to the law. On a basic level, businesses are subject to the new Chinese law if they process the personal data of Chinese data subjects in order to provide products or services to data subjects in China, to analyze or assess the behavior of data subjects in China, or in other circumstances as provided by Chinese laws and regulations, which are not defined.
The next question on everyone's mind is usually, what happens if I violate the law? According to Article 66 of the law, penalties can include the suspension of business operations, fines, and personal liability. Penalties for great violations can include a fine of up to approximately $8 million or 5% of annual revenue.
The next area of discussion is what you need to know from a data governance perspective. The new law contains a single record-keeping requirement related to the subject of data impact assessments. Data impact assessments are assessments that must be made in advance by persons who handle sensitive personal information, use personal information to conduct automated decision-making, entrust the handling of personal information or provide such data to other handlers, or disclose personal information to such persons. Another category of persons subject to this requirement are handlers who provide personal information abroad. Finally, the data impact assessment obligation applies to the broad category of personal information handling activities that exert a major influence on individuals. Impact assessment reports and handling status records must be kept for at least 3 years. For other retention periods pertaining to personal data, for example, the retention periods applicable to employment law records, persons processing personal data must consult with applicable Chinese law, which can include both statutory retention periods and statutes of limitation. These retention periods are important because the law provides a general obligation to destroy personal information that is no longer needed. Our experienced team of information governance professionals at Knowledge Preservation can help your team to navigate the laws, rules, and regulations relevant to your business. We also provide training, draft and review your policies and procedures, and other similar types of information governance services.
Contact us today to discuss how we can help your team achieve information governance compliance.